This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about how an appeal failed when the ground for judgment in the trial court was not disputed, and where a flood exclusion applies to defeat a claim. The insured admitted that the loss she was suing about was caused by flood, and the trial court found that standing alone was sufficient to grant summary judgment to the insurer whose policy clearly and unambiguously excluded flood. Virginia Sosa appealed from the county court's orders granting summary judgment in favor of the Auto Club and denying her motion for new trial. The court granted summary judgment on several grounds raised by Auto Club, including that Sosa's claims were barred by limitations and by the exclusion in her homeowner's insurance policy for damage caused by flood and surface water. In Virginia Sosa versus Auto Club Indemnity, the Court of Appeals of Texas decided on August 30, 2022, that because Sosa did not challenge the summary judgment ground that her claims were caused by flood or surface water, which was expressly excluded from coverage under her homeowner's policy, that the trial court was correct in granting summary judgment. Sosa's house was damaged during Hurricane Harvey on August 26, 2017. Shortly thereafter, Sosa filed a claim with Auto Club which insured her house. Sosa reported that 2 feet of floodwater had entered her home, her roof was missing shingles, and was leaking, and she had sustained interior damage. Auto Club determined her damage was caused by floodwater, which was expressly excluded from coverage under her homeowner's policy. On September 26, 2017, Auto Club denied her claim. 3 years later, on November 11, 2020, almost 3 years after the denial and more than 3 years after the damage, Sosa filed suit against Auto Club for breach of the insurance policy. Sosa filed a first amended petition, which was her live pleading, when the county court entered summary judgment against her. Sosa's amended petition was identical to her original petition, except that it changed the date of loss from August 26, 2017 to June 28, 2019, apparently to avoid the holding of the limitations period in the policy. Auto Club filed a traditional motion for summary judgment, arguing it was entitled to judgment as a matter of law on several grounds. Auto Club argued that Sosa's claims are time-barred by the 2-year and 1-day limitation period contained in Sosa's policy because Sosa filed the lawsuit more than 3 years after her claims accrued, and that Sosa's policy did not cover loss from flood or surface water, which it contended was the basis of Sosa's claimed damages. The county court's ruling and motion for new trial were resolved by the trial court because of the various defenses asserted by the Auto Club. Sosa, as an appellant, must challenge each independent ground that could fully support the trial court's challenged ruling. When an unchallenged ground supports a complaint of ruling or judgment, the Court of Appeal must accept the validity of that unchallenged independent ground, and thus any error in the grounds challenged on appeal is harmless, because the unchallenged independent ground fully supports the complaint on ruling or judgment. Auto Club sought summary judgment on 4 grounds, and the county court granted its summary judgment on all 4 grounds. 1. Auto Club argued Sosa's claims damages were excluded from coverage under the homeowner's policy, and therefore it was not liable for her damages. 2. Auto Club argued that Sosa's claims were time-barred. 3. Auto Club argued that its evidence disproved several elements of Sosa's breach of contract claim. And 4. Auto Club argued that Sosa's extra contractual claims were not viable in the absence of a breach of contract. On appeal, Sosa challenged only 3 of the 4 grounds. Sosa did not challenge the summary judgment order on the ground that her claim damages were covered under the policy. Indeed, her appellate brief does not mention flood or surface water. A policy provision that excludes claim damages is an independent ground that supports dismissal of such claims because Sosa's claims are contractual in nature, and Auto Club's liability for her claims flow from the homeowner's policy. Auto Club cannot be liable for damages that are expressly excluded under the insurance policy. The appellate court concluded that it need not decide whether summary judgment is meritorious on all stated grounds by the county court in order to affirm. Because Sosa did not challenge the ruling on appeal, the flood exclusion ground independently supported summary judgment in the Auto Club's favor. Any other error about which Sosa complained on appeal is harmless considering the unchallenged ground supporting the summary judgment order. Because summary judgment was proper, the county court did not abuse its discretion by denying the motion for new trial, and the Court of Appeal concluded that the county court did not act arbitrarily, unreasonably, or without reference to guiding rules or principles in denying Sosa's motion for a new trial, and therefore the trial judgment was affirmed. In my opinion, the facts established that Auto Club had 4 viable grounds for summary judgment, one of which did not even dispute nor was even mentioned in her appellate briefing. As a result, the Court of Appeal had no choice but to affirm the decision of the county court because her pleadings admitted that the Auto Club's position was correct. That she tried to cheat by changing the date of loss was contumacious, but in effect a wasted effort that should have been sanctioned by the Court of Appeal but was not. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone at zelma.com/blog. If you found this video to be useful or interesting, please tell your colleagues and friends about it so that they can also view this video on YouTube or on Rumble. And they could also read the blog postings and subscribe to either the blog postings or the videos at their leisure. Thank you for your attention.